Hello everyone and welcome to the mini presentation slot session. This session has been sponsored by our session sponsor, BioPharma Law Group PLLC. And the speaker for this session is Joanna Brougher, owner and principal, BioPharma Law Group PLLC. And the topic of this particular session is vaccines and IP rights, especially in the view of recent discussions surrounding IP waivers and compulsory licensing. So thank you, Joanna, for your sponsorship, and you can take the stage now.
All right, thank you very much, and thank you to IPR Gorilla for inviting me to talk today. So today I'm going to be talking about vaccines and IP rights, and for anyone following what's going on in the pandemic, I'm sure you've heard by now the discussions surrounding compulsory licensing and especially IP waivers. And this is a really interesting topic for me because I've actually been teaching about compulsory licensing for about 10 or 11 years at my class at Cornell and before that at Harvard. And it's always been interesting because not many people focused on compulsory licensing and what it means until the pandemic started. And now there's a lot of news about compulsory licensing and a lot of people have a very strong opinion about what it means. So in the limited time that I have with you today, I want to go over compulsory licensing, what these terms mean, where they even come from, and kind of how they play out in today's pandemic setting. And I really just want to give you kind of a foundation for understanding these topics and for being able to understand the different arguments and discussions that are surrounding them in the news today. So as I mentioned, today we're going to be talking first about the TRIPS agreement, which is really provides the foundational argument or the foundational legal documents for compulsory licensing and by the extension, the IP waiver. Then we're going to be looking at these two different concepts, both compulsory licensing and IP waivers and what they mean and kind of how they've played out before in the past. And then we're going to look at today's COVID environment and see if these actually make sense and what are some of the hurdles to either using a compulsory license or an IP waiver. So first, let's start with the TRIPS agreement. This is the trade-related aspects on intellectual property rights agreement. This was signed into effect back in 1994. And the goal of the TRIPS agreement was to harmonize patent laws across all nations. And this applies to any country that is a member of the WTO. So if a country wants to become a member, they have to agree to the TRIPS agreement. The TRIPS agreement sets a basis for IP rights that countries have to abide by. The three main things that the TRIPS agreement requires is that countries give out patents for inventions that are new, that are susceptible of industrial application, and that involve an inventive step. Anyone familiar with patent laws will understand that these are very similar to what we have in the US, but in the US they are called novelty, non-obviousness, a patentable subject matter. And in Europe basically follows the same guideline of new, susceptible of industrial application, and an inventive step. The TRIPS agreement came about in 1994, as I mentioned, to harmonize patent laws. Prior to 1994, countries had a wide range of different requirements for patents. Everything from in the US, we had 17 years of a patent term after a patent has been granted. In many countries, especially developing countries, you may have seen like 5 years, maybe 7 years, or even no years. In India, for instance, patents were not even granted for pharmaceutical products or processes. So the TRIPS agreement meant to harmonize everything across all countries and give patent owners and patent holders an even playing field in different countries. While the TRIPS agreement did set basics for patent rights, it also recognized the need for countries to account for its own public health. These two articles, Article 8.1 and Article 31, are the main articles on this point. Article 8.1 says that members may adopt measures necessary to protect public health and nutrition, provided that such measures are consistent with the provisions of this agreement. Countries, including India, and I'm going to use India as a great example for this because India came up with requirements in its patent laws that says that you cannot get a patent on the same invention more than one time. As anyone who knows patent law in the US will know that you can constantly get a patent to a modification or an improvement of an invention. In India, that is not the case. You are only entitled to one patent, and all other countries fall somewhere in between those two. Article 31, however, has this compulsory licensing provision. And this is anytime somebody talks about compulsory licensing, it comes back to Article 31 of the TRIPS agreement, which says that countries can issue a compulsory license in the case of a national emergency of extreme urgency. So what does this mean? It means that a country can ignore a patent that is in that country and allow its manufacturers to start making products for its market. Best examples of this are in Brazil. So in the early 2000s, Brazil was fighting an HIV epidemic, and Brazil used the threat of compulsory licensing in order to negotiate discounted rates for HIV medicines. In many cases, they were able to reduce the prices of HIV medicines by up to 65% or even more. Eventually, they also started issuing their own compulsory licenses and going ahead and manufacturing these products. What made Brazil so effective in compulsory licensing was that they had the manufacturing capabilities of manufacturing drugs for their domestic market. And this is kind of part 2 of the compulsory license requirements. It's that a country has to be able to manufacture just for their domestic market. Obviously, a lot of countries out there do not have the ability, similar to Brazil, to manufacture a lot of drug product for their own market. And this is where in 2003, the TRIPS agreement was amended to allow for export licenses. So this would allow a country, a developing country, to seek another country to manufacture that drug and export it to them. The potential recipients here are least developed countries who do not have the capability of manufacturing drugs in-house. The only example of an export license is the situation with Rwanda and HIV drugs again. And Rwanda turned to Canada, to Apotex, the generic manufacturer in Canada, to manufacture HIV drugs and export it to Rwanda. This process took over 3 years, had a lot of complications, and Apotex came out and said that they didn't make any money off the process, so they were not very happy with it. To my knowledge, that is the only time an export license was ever used. So it's clearly not a very efficient or well thought out, well-known process. So let's move on to compulsory licensing and the current COVID pandemic. When the pandemic started and kind of started taking effect, we saw a lot of discussion about compulsory licenses. Israel actually came out, I believe, in March of 2020 and granted a compulsory license for the generic antiretroviral lopinavir and ritonavir from AbbVie, thinking that this could help with COVID. AbbVie at the same time announced that it would not enforce its patents. So it was kind of, it was an interesting view of compulsory licensing and how a company would respond to it. Other countries such as Chile and Ecuador adopted different resolutions allowing for compulsory licensing of technologies that are related to COVID. Canada also changed its domestic laws to remove the requirement that a country has to negotiate with the patent owner, which is also one of the requirements of a compulsory license. And then we also saw Germany and France taking steps to making compulsory licensing easier. However, having said all that, there really hasn't been too much more going on with compulsory licenses. I'm not sure how the Israel situation has played out, but I haven't seen much more taking place with compulsory licenses. Everyone seemed to move to IP waivers, which is kind of the first of the discussion about IP waivers that I've seen. An IP waiver is slightly different than a compulsory license. And under an IP waiver, a country would choose to neither grant nor enforce patents. India and South Africa were the first 2 countries to kind of promote this idea back in October of 2020 when they asked the WTO to allow for IP waivers related to COVID-19 drugs, vaccines, diagnostics, and other technologies. And as you can see, this is a broad ask. It's basically asking for waivers related to any sort of technology that could be in effect, not only the vaccines, which we're talking about today. The Biden administration, within the past month and a half or 2 months, has actually come out and said that they do support an IP waiver for COVID vaccines. When they came out with this, as you can imagine, this sparked quite a lot of debate. Many players on the industry side viewed this as kind of a taking of IP and viewed this very negatively. There's obviously parties on the other side who are supportive of this. So let's take a look at some of the main hurdles to issuing any sort of compulsory license or IP waiver. And this is definitely not an extensive list, but it's meant to get people thinking about how some of the challenges just of issuing a compulsory license and IP waiver is in different technology settings. And I think one thing you have to think about is think about the technology itself. In the case of the Moderna and the Pfizer vaccines, for instance, which is what the main focus has been on, these are both new technology vaccines. They're both mRNA vaccines. This is the first time we've seen these types of vaccines. Not a lot of people are familiar with the technology behind them and how to manufacture them. The HIV drugs that we talked about with relationship to Brazil or other countries that have gone ahead with compulsory licensing, they were much simpler. They were more chemical-based drugs that are fairly easy to manufacture once you have a formula for it. With the mRNA vaccines, these are still new technologies that a lot of people are not familiar with. Because of their newness, there's also a lack of disclosure and a lack of know-how of how to make these vaccines. On top of that, a lot of the vaccine manufacturing process remains a trade secret. So just not having the information of how to make the entire vaccine is going to be a challenge for anyone who wants to go ahead with either a compulsory license or an IP waiver. You still need to have access to all of that information. The patents surrounding these vaccines were probably filed earlier on in the COVID pandemic, which means that they are only now becoming public. They have not been public until this month or next month, just given the timeline. So there's still some uncertainty with how to manufacture these. On top of that all, the manufacturing process for making these mRNA vaccines is extremely difficult. Pfizer came out with a 19-step process of what it takes to manufacture them, and any sort of deviation from that process can jeopardize the efficacy or even the safety of the vaccines. There is one US-based manufacturing plant that had to dispose of a lot of vaccine product because they messed up in one of these steps. So it's not an easy process by which one can easily just start manufacturing vaccines. Finally, and I think this is probably the most important one, is simply time. By kind of putting together the new technology, the lack of information surrounding it, all of the trade secrets that people need to have access to, the difficult manufacturing process, by the time a country wants to get up and running and up to speed with how to make these vaccines, the pandemic will probably be way over. In fact, I believe the numbers were something around that we need 19 billion doses before we reach that magic number of 70% of the world's population being vaccinated against the virus. And according to the industry, at least according to Moderna and Pfizer, they're going to have that 11 billion dose supply by the end of the year. So I think we're much closer to getting that herd immunity that we are striving to by just allowing Moderna and Pfizer and the other companies who are manufacturing vaccines to continue manufacturing them. So with that, I'm going to stop sharing. And I know this is a lot of information that was covered, but I'm happy to answer any questions that people may have about this very interesting topic surrounding vaccines and IP rights.
So thank you so much, Joanna, for sharing with us such insightful information regarding the vaccines and the situations that have been going on, and giving everyone hope that by the end of this year we will be, in a better situation than we are in right now. So I would like to ask the attendees that if they have any questions, so please share your audio and video, come live and ask the question to Joanna, or you can also write down in the chat box or in the Q&A section on the right side.
Thank you.
And we have a comment from Nirupam saying that it was a great session. Thank you so much. He states, minor correction, India had processed parents from pharma.
Process patents, okay, but not the composition patents. Thank you.
Thank you.
Thank you.